Good afternoon to everybody. We are expecting a few more people, but I'm going to start promptly at 1 because Marion's got an action-packed hour planned for us, and I don't want us to run out of time. We are recording and we will make the slides available, so sit back and relax and enjoy what she has to share for us. Just a quick introduction. Marion is a director, as most of you know, of conflict dynamics. She is an esteemed trainer and dispute resolution practitioner, having been involved in political and community advocacy since the 80s, when she was involved at IDASA, facilitating processes leading to democratic change. She was also involved in the Needsbased process. She then obtained a master's in dispute resolution at the Notre Dame University in the States, and lucky for us, came back to South Africa to be able to share her skill with us here. We're delighted to have you, Marion. A very warm welcome to you, and we look forward to what you have to share with us. I know Marion wants to be interactive and encourages questions and engagement, so please feel free to stop her and ask questions, otherwise post in the chat box, or we will make some time at the end. Marion, over to you.
Yeah. Great. Thanks so much, Michelle. Thanks for having me. And thanks everyone for joining in. I mean, this is obviously a topic that us at Conflict Dynamics are feeling very excited about and positive about. Because we've seen in the last couple of years, since Rule 41A has come into place, we've seen a massive increase in the number of requests for mediation of our mediator panelists specifically. So that's a way of really seeing it. And there just does seem to be a heightened interest in doing this properly. So I'm really excited to be speaking to you about this today. As Michelle said, it really is an opportunity for you to ask questions and engage. So please feel free to chip in with questions at any point. I will try and keep my eye on the chat. So if you want to post questions there, but I'm actually going to ask Michelle to keep her eye on the chat as well, because sometimes I get a bit carried away when I'm sharing the information. So yeah, multitasking is not always a thing for women. Trust me, I'm not a very good multitasker at all. So yeah, I do recognize a couple of people who I know. So hello to everyone I recognize, and hopefully I'll get the opportunity to chat to people I don't know or recognize. Yeah, I've prepared a slideshow. So these slides will be made available to you afterwards. So it's there's no need to take notes while I'm presenting. I will send these, or Michelle will send these through to you after the session. But really what we're going to be looking at today is just speaking to you as attorneys, as representatives of your clients more than anything else. I do know that a number of you are accredited mediators and probably are mediating at this stage, but the focus really is today on your role as an advisor to your clients and as a representative to your clients in the mediation process. And this really does become more and more critical as the High Court really now insists on mediation being considered, at least. I mean, it doesn't have to be embarked upon, but it has to be considered, and there has to be given good reason as to why mediation isn't appropriate for all cases that are requesting dates in the High Court. So it does become really important that the process at the end of the day doesn't become a tick box exercise. And I mean, that's what we're concerned about at the moment. We've seen other systems where there's been a kind of a statutory need for a consensus process, that it has in many instances, or in some instances, ended up just as a tick box exercise, where attorneys kind of go through the motions, but aren't really there to assist in reaching a consensual outcome of the matter. So that's why we're spending quite a lot of time training attorneys and advocating for attorneys to become real advocates of mediation. Good, so let's start at the very beginning, so to speak. What I've got in front of you there on this slide is something that you've probably all seen if you've been to any of our courses. It's just really an indication of the different dispute resolution processes. And there's going to be absolutely no surprise in it to you. The first process there is really an indication of the negotiation process. So two sides, two parties on opposite sides of a table, really trying to get to an agreement or a solution, which is the aim of any negotiation process. Now, as we know, what often happens in those negotiations is they may not succeed, and there may not be a settlement. And in those instances, disputes often, either are dealt with through power, or they can go to other consensual dispute resolution mechanisms like mediation, which is the second process we're trying to illustrate here, or they go to a adjudicative process indicated by arbitration and a court litigation in examples 3 and 4 below. But what you'll see really is that mediation is an extension of the negotiation process. So in the center of the slide, we have the negotiation process with a mediator at the top of the table who's brought in really to assist parties to negotiate a settlement. The mediator has the opportunity to work with the parties jointly, so work with them around the same table and share information and get clarity on issues in the same room, around the same table, or to work with the parties separately on a confidential basis. So the mediator has the wonderful opportunity to see the dispute from above, so to speak. They know what is in it for the parties jointly, but they also know what the priorities or the underlying interests are for the parties separately, and is in that way able to construct a settlement between the parties. We often refer to it as, negotiation on steroids. Having a mediator in the room is just negotiating on steroids, trying to really get the parties to negotiate effectively. The phases of the mediation process, and again, I'm going to just really go through this quickly, is there is a lot of preparation involved in any mediation process. If you've been involved in one, you'll know, the parties start speaking about mediation. They start thinking about when is the right time to mediate a dispute. They then try and select a mediator, share all the information, the documents relating to the process up front, and eventually they get into the room with the mediator. There's the opening of the mediation process, which usually happens jointly with everyone around the same table, unless there's a very, very good reason for that not to happen that way. And then what the mediator would do will be to explore and analyze the dispute jointly with the parties, but also in side rooms separately with the parties, generate options for consideration with the parties, again, either jointly or separately, but in the mediation process, we kind of train and are most familiar with. This often happens in private side sessions. The mediator will then work with the parties to choose options and to start the bargaining process. In other words, developing the settlement, trying to reach that agreement between the parties. Hopefully, there's an agreement and that agreement is finalized, or if it is not finalized, deadlock can be confirmed and the necessary processes to take the process forward can be discussed at this point when deadlock is agreed. And often there's also some follow-up required. So you may have agreed on some issues but need to consult on others, and the mediator then stays involved to ensure that follow-up. This all looks extremely linear and clean and clinical, and I can assure you it is not. And any good mediator will really use this process flexibly. So, you know, you may get to final settlement and be drafting an agreement with your parties and then realize that there's a whole new area that needs to be explored, and then you'd need to go back with your parties to explore that and fit it in to that agreement. So it's a very flexible process which allows the mediator the ability to move between these different phases of the mediation process, depending on what the issues are and what the processes look like thus far. Can I just stop and catch my breath here and really ask, are there any questions relating to these phases of the mediation process?
Ishara, do you want to go ahead? She's popped one in the chat.
Yes, actually, I'm just busy writing a second one. Hi, Marion, how are you?
Good, thanks, Ishara.
Thanks, Marion. I just wanted you to share with us your advice on the mediation venue. So I've had the situation where one of the parties has offered their good offices as a mediation venue, and I rejected it just because of the appearance of non-neutrality, etc. What's your advice on that? Because also their argument was that it would cut down the costs as well. So what's your advice on that?
Well, I think it really depends on how comfortable the parties are about meeting at either one of their offices, you know, and it depends a lot on what the dispute is. I mean, what I can tell you is often in commercial disputes where, you know, the issues are not as much maybe around people feeling uncomfortable in certain venues as one often gets with workplace or employment disputes. In commercial disputes, we often find that the lawyers agree the venue quite quickly, and it's often at one of their premises, and then it's available. So it really does depend, and I think you have to be sensitive to your parties and you know how comfortable they'll feel in a venue. But I'm trying to think, certainly sort of this year, to give you an idea, all the mediations that I've done this year, which is a solid handful, have all happened at the offices of one of the attorneys.
I see, okay.
So when parties are represented, that's also sometimes a benefit. You know, the lawyers, you know, can facilitate that kind of discussion and those arrangements. And that is often always the case in Rule 41A mediations is, you know, the parties are represented.
Yeah. And my other question was just you mentioned that under certain circumstances, there may not be a joint opening meeting, or the parties may not be having a face-to-face first meeting for the mediation. Can you maybe elaborate on what are those possible circumstances?
Again, I think it's really important to have that joint opening session, because it's really an opportunity to as a mediator, establish the processes you want to run it, to build your unbiased impression from both the parties. So I think it's a really important aspect, and I wouldn't encourage any mediator not to do it. The only time I have not had joint openings have actually been in medico-legal mediations where emotions are just too heightened at the beginning of the mediation to have people in the same room. You know, the one instance was a mother who had lost a baby, and it was the one party, and the other party was the doctor, the obstetrician, who was overseeing that birth, and they just couldn't be in the same room. So in that instance, I just took the opening into the side rooms and then shuttled between them for the full duration of the mediation.
I see. Okay. Yeah. Thanks. That's what I thought as well. Thank you.
Pleasure. Good. Okay. So this gives you a sense of what your mediator is going to be taking you through in terms of these phases and using these phases as a way of hopefully reaching settlement or getting to a point where at least the parties have worked on the issues and maybe narrowed the issues or got some kind of settlement, even if it's not a full settlement. Okay, just to take you, why isn't my cursor working? Oh, I've got lots more. Okay. So just to take you to the ground rules of the mediation process, I mean, just through with a show of hands, can you give me a sense in the room of how many of you have been in a mediation process before? You've all got little responses, I guess. You can respond. Okay, so we've got about 4 so far, 5, 6. I'm just trying to get a sense of how much detail I need to go into, or whether we have a whole lot of mediators who have a good sense of the process already. Okay, well, it does seem as if the majority of you have had exposure to the process. So I'm going to move faster just as a result of that, if that's okay. Good. So the mediation ground rules are kind of clear. It's a consensus-based process. So you're trying to reach settlement. You're helping parties to come to an agreement rather than making any decisions. The role of the mediator is to respect that and to really work with the parties to reach consensus, unless, of course, you've been appointed as an adjudicative mediator. So and that happens in some instances, but mostly I would say the type of mediation that is encouraged through most of the statutes that call on it, and certainly in the private mediation sector, is a much more facilitative process of mediating. It's been really interesting to see, though, just in the mediations that I've been doing under Rule 41A mediations, is that often the parties and their representatives do not understand the role of the mediator. So they are actually, and make it very clear early on in the process, that they want you to make a decision or make a recommendation. So it's really important to ensure that your clients understand the role of the mediation and what they're about to get into. The other ground rule that really assists the process is the confidentiality principle. It's a confidential process in its entirety, and also in terms of the information you as the mediator get in those side meetings with the parties individually. So really important to use that confidentiality principle, and the fact that it's off record, it's without prejudice. So if there's no settlement, it can revert back into the court system. And I mean, that's the real intention here with Rule 41A mediation. So it's useful as a mediator to use that often and to reassure parties that this is really just an opportunity to put an end to the process. The other ground rule, again, to remind parties of often, is that there is no agreement until there's a written agreement and it's been signed by the parties. And that's also reassuring, because it allows them to open up and think of options and possibilities without having to feel as if they're committing to them early on in the process, especially. It's a voluntary process. And again, you know, this principle of voluntariness is so useful, because once parties are in the process and they've gone to the effort of getting there and getting prepared to mediate, it's really useful for them to know they're there of their own volition. And it's useful to remind them of that when there's when you come up against resistance. as a mediator specifically. And then the issue about authority is also one just to keep in mind as attorneys, but of course as a mediator as well, and to ensure that, that you understand what the mandate is and whether the people in the room actually do have the authority to settle. I have had a couple of problems with that in mediators, in 41A mediations, where the right people are just not in the room. You know, a legal rep has been sent, again, possibly to just tick this box, and that can be really frustrating as a mediator. Good. Any questions about the ground rules? Viv, have you got a question there? Is that a hands up?
Hi, no, sorry, that's a mistake. I need to take it down.
Oh, is that from
that was from earlier. Sorry, I've lowered it now.
No,
thank you.
That's great. Perfect. Good. So no questions on that. What makes mediation work? I think those rules that I've just gone through, or those principles, as we like to call them in the process, and the structure of the mediation process really does allow mediators to gain a unique overview and insight into all aspects of the case. You know, I more often than not have parties leaving a mediation kind of commenting about the fact that they have new insights and they have new understanding after the process, whether it settles or not. I mean, obviously when it settles, they're delighted and they're full of praise. But even if it doesn't settle, I think there's a real opportunity to gain those insights and a better view of the cases. Mediation focuses on the parties' needs and interests rather than evaluating their positions. And that's also a conversation which is really useful for parties to have, and for parties and their representatives to have on, you know, what's really motivating them, what's really upsetting them about the process, what do they really want to get out of it rather than a decision by someone. So that's the other reason that mediation often works. And then the mediator can facilitate better understanding in the development of options because of the way that the process relies on an understanding of those needs and interests. So in my experience, that's often why the mediation process works. Again, please shout if there are any questions, just interrupt me. We often speak about this, you know, about the fact that it's a needs-based or interest-based process. And just to illustrate that, what we often find is that lawyers are very focused on the facts. Sorry, I'm just going to open all this up. They're very focused on the facts, on the legal positions that they've taken, and on what happened in the past. I mean, that is what your litigation process really focuses on, and is driven at solving the issues around the facts, the legal positions, and what has unfolded so far. As mediators, what you're really trying to do, though, is you're trying to move parties away from that. You're trying to move them towards how the parties are experiencing the process now, what the commercial implications are, what they're feeling about where they are in terms of the process, and then on to what would they like to where would they like to be down the road, you know, what are some of their ideal outcomes to the situation, what their personal circumstances are, and really trying to get away from those backward looking facts, legal positions past, towards the future and some resolution of where it could be. Any questions related to that? Good. So that's what we're kind of exploring as mediators. And what that takes us to is moving from those positions to the interests. So you'll enter any mediation with parties putting their positions on the table, or they've put it on the table in writing before. You know, they've shared their demands or their positions, and what you're trying to get it to is like what's really going to work for them at the end of the day, rather than focusing purely on those positions. And just to illustrate that, and I'm sure you've all seen this analogy 1,000 times, it's that age-old issue of what's above the surface and really what's below the surface. How do you understand the needs, interests, fears, concerns? And where as a mediator you can find that overlap between the interests and start then in a sense unlocking value. And that takes us to this idea of the size of the pie, and just how important it is as a mediator to not only assist the parties on dividing the pie, but during that process, creating value. So creating additional issues, additional considerations, a sense of what the prioritization is of different issues that are on the table. And in that way, really creating value with the parties, so that once you start dividing it and bargaining and coming up with a settlement, there's much more to it than those initial positions that were initially brought into the room and placed on the table. So you'll understand as attorneys, your role is really to, in some way, assist this process of creating value and then claiming value or dividing value, so to speak. Okay. Any comments? Questions? Good. So now just a little more detail of where exactly lawyers are, or attorneys or representatives are most involved in the process. And just to really introduce this slide, our experience at Conflict Dynamics, and certainly the way that we'd argue for this quite strongly, is that it's really, really useful to have lawyers involved in the process. And it's particularly useful when they understand the process and they're working with you as the mediator to try and achieve some kind of consensual outcome. So we much prefer having lawyers involved, to be honest, because, you know, it's the whole thing of being inside the tent or outside the tent. The reality is most people do have legal advice, you know, especially if these are substantial disputes. There are always lawyers in the background who have opinions, who have approaches that they think are correct for a party. So it's just really useful having them as part of the process, rather than parties feeling insecure and needing to report back all the time, and then they're reporting back to someone who hasn't been part of the process and therefore hasn't picked up on, you know, the granularity of the discussions that have happened so far. So our approach is always, whether people are represented or not, to encourage them to bring their advisors into the process rather than keep them out. So our approach, our approach is really, in the preparation, lawyers are critical and very, very involved. Obviously, in Rule 41A mediations, the lawyers are the ones who bring the matter to mediation, whether they've got a sense of wanting to really settle or whether they are just doing it to go through the motions and to comply with the rules. The reality is they're involved in setting this thing up. So during that preparation phase, they would make all the decisions around the logistics. They will decide what is included in the bundle, the mediation bundle, or the statement of mediation, as we encourage them to put together. They will send that, they will share it. They will share it with the mediator, but also with the other party. They will discuss the venue, as Ishara raised earlier. They will determine what a good venue would be. all those type of logistical arrangements are often really driven by the lawyers in the process. Once we get to the opening, often the lawyers are the people who make the opening statements. I try and encourage parties to participate in that in some way, but they're often at this point still feeling, you know, like maybe not that confident yet. So they may get their lawyers to do the openings, but that's absolutely fine. But certainly I would draw the clients or the actual parties into that discussion immediately to get maybe a more varied kind of sense of where things are, even in the opening. Once we get into side sessions and we start really exploring and analyzing the dispute more, so really for me to understand what's happening as a mediator, I would rely on getting quite a lot of information from the actual parties and really test things with the legal representatives. But at that point, the conversation's often with the parties and where they are and where they're wanting to get to. In the generating of options, the same, you know, still very involved there, but certainly not excluding the lawyers at any point, because here is, you know, lawyers often would have very, very good ideas of how, you know, what the options are and which way things could go. Once we start the actual bargaining, so hopefully by now we've created a certain amount of value and we're trying to set up a settlement that takes a number of things into consideration, the lawyers become much more involved, because they at this point can also really work with their clients to analyze the risk and to work on, you know, what the potential, you know, just compromises are that they could make. So I would work quite closely with the lawyers during this process, and certainly in the agreement, the lawyers that's what they do. They know how to draft agreements. I would oversee the drafting of that agreement, but leave it largely to the lawyers to put onto paper what has been agreed during the mediation process. And if there is follow-up that's needed, that would 10-to-1 happen with the attorneys. So based on this, you can see that there's an absolutely pivotal role for attorneys in the mediation process, but also a real need for attorneys to understand their role, you know, to understand that they're not there to litigate. They're there to try and find a resolution of some kind. So there is a real kind of shift that is needed. And, you know, when you see that shift in an attorney or you experience it as a mediator, it just really does unlock the process to a large extent. So this is an extremely useful book. And, you know, when you get the slides, I think you get the references as well to the book that we've used at different levels. So I'll make sure that that's on it. But there has to be a change in attitude and approach on the part of lawyers if we want to see settlements happening. And the reorientation is really from the focus of to focus on the settlements rather than the adversarial forensic debate that often happens initially, especially with lawyers. There needs to be a rebalance. So the focus of not presenting a case, but rebalancing on and looking for settlement. So being fully prepared and understanding what a good settlement is for your client. And then recognizing that decision-making is often flawed and that our positions are often really based on emotions and biases that the parties have and that you as an attorney often kind of support and encourage in the parties. So it's really useful when the attorney starts seeing themselves as someone who's there to really look at options rather than be stuck on those positions. Okay, so I'm not going to deal with any of the case law because I'm sure I'm dealing, you all are totally on top of this, and but there is case law, and I think there's more and more that will come out now in the next while. We've had a couple of situations already where cases are being referred to us because judges have said this thing needs to go back and get mediated. We're not, we'll convene again in 6 weeks' time to give you an opportunity to mediate because this hasn't been mediated yet. Or so we're definitely seeing that move among some of the judges already. And, if there's resistance to that, I guess we'll start seeing new jurisprudence developing around that. But we do also now, of course, have this rule which does encourage it, and hopefully, attorneys will be encouraging their clients to use it fully as well. Okay, I'm just going to stop just to again ask if anyone has a question before we go on to a negotiation strategy. I do want to give us a good couple of minutes at the end for questions and discussion. Doesn't seem as if there are any hands. Is there anything in the chat, Michelle?
No, nothing, Marion, thanks.
Okay, great. Okay, so what this means for attorneys really is that, a lot of time is to be spent with your clients on developing a negotiation strategy, on really thinking about, okay, we're not necessarily only going to fight this in the courts, but we're going to take a step back and think about negotiating it and what our strategy then should be in terms of that negotiation process. So the objective really is for the client to be able to make informed decisions about what is a good settlement, if there is one. And in most instances, I think we can all agree there are good settlements. So that initial consultation with the client, or maybe the consultation that happens prior to the Rule 41A process happening, is speaking much more broadly. As per that slide I spoke about earlier about the past, the legal positions that get taken, and the history of the event, speaking much more about what the client's goals are with litigation, how strong the client's financial position is, considering the impact of various scenarios, like, what happens in this case, in the next case, in the next case, like looking at all those scenarios, and working with them on understanding them. What is your client's appetite for risk? What is the main obstacle to an early settlement, and how do we overcome those? So if it's a relationship issue, or if it's an information issue, that there's just no information available, I'm trying to address those through the mediation process potentially as well. How is your client affected by non-monetary factors? I mean, I'm always absolutely amazed in mediations how much value there is in a apology, even if it's in a guarded apology or a qualified apology. Often that can unlock a whole lot of other settlement options. So speaking to your clients about those aspects, and really understanding them before you go into the mediation process. Doing a risk analysis with your clients, so understanding the alternative scenarios and what they could result in, understanding the cost implications, quantifying the litigation risk. I mean, I'm again always amazed at how attorneys will say to me as the mediator, oh, we've got a rock solid case here. It's a rock solid legal case. We'll win if this goes to court. And, there really is, in many instances, not that much guarantee of that happening. And we run an advocacy one-day training program for attorneys in which we give them a few kind of formula that they can use based on actual success rates in litigation in the courts. And they can do a real litigation risk in terms of rands and cents with their clients. And that's really that net cash position analysis. So if we go to court, how much is it going to cost us? What are our chances of settlement? At least what are our chances of winning at the first level, at the second level, at the third level, if we have to take it that far, just so that people really have a sense of what they're in for. In the UK jurisdiction, that information has to be made available to the before you go to court even. So those documents have to be made available and have to be made available to mediators, which obviously helps a lot in getting settlements. Also, just in terms of advising your clients, understanding the other side's case, so doing a little bit of work on that. I mean, I was a bit distressed recently in a mediation where at the beginning of the mediation, the parties were quite open in telling me that they haven't spoken to the other side for a good couple of years, and they were really just here to understand the other party's case. They were using mediation for that process. So I think it really is important that parties start speaking earlier, and hopefully Rule 41A encourages parties to start sharing those mediation documents, mediation statements prior to the mediation, and getting a sense of how to solve a problem rather than how to litigate it only. So the outcome is an informed negotiation strategy. Do we want to mediate? And when is a good time to mediate? Qualified settlement ranges, so understanding what the range of settlement is, at what point does it not make sense for me to negotiate anymore? Doesn't seem to me that parties often do that analysis before they come into a mediation process. As a mediator, I often have to do that with them in side session, rather than them coming in and understanding, look, at 100,000, I really have to walk away, or at, whatever the amount is, but really doing that work. And then understanding the strengths, the weaknesses, the needs, the interests, the obstacles that your clients may have. Okay. Any questions on that whole negotiation strategy? And I mean, I think it's a lot of work, and it's a lot of work that often happens in the mediation, which ideally, and I think parties would be so much better represented if it happened prior to mediation. And you just get better settlements, I think, at the end of the day, if all this work's done before. I'm very happy to do it during as a mediator, but yeah. Questions, comments? Okay, great. So the agreement to mediate. As a attorney representing someone at mediation, this is the first thing that you'd have to apply your mind to, is your agreement to mediate. And that really is the contract that will oversee the mediation process. So it's, and all the parties, including the mediator, sign up to the agreement to mediate, so that it's very clear what is being required of the mediator and what the responsibilities of the parties are relating to the mediation process too. So again, you can go onto our website and find a couple of examples of agreements to mediate. I'm sure you already have them, and you would have to put that together prior to the mediation and get it signed off by everyone involved. Okay, choosing the mediator. I think it's probably the most important decision you make as a representative. And there are obviously really objective criteria that are important to consider. The first is just some kind of membership to a professional organization or a panel. This will mean that your mediator is signed up to a code of conduct, and you can expect your mediator to operate according to that and hold them accountable to mediate according to that code of conduct. It will also mean that your mediator is trained and accredited by by hopefully a good training provider. It would also mean that there's a level of experience. Your mediator's done this before, and they're not trying this out on you for the first time. It may also mean that there's a certain amount of expertise in a subject matter area. So, for instance, at Conflict Dynamics, if you approach us and you say you need a mediator, we'd say, okay, well, what kind of dispute is it? You may say, well, it's a shipping dispute and it's a contract in the shipping industry. And then we can actually go through our database and take a look at, who's got previous experience in that industry and who's got expertise in contractual disputes. So you find someone that has a good level of understanding of the dispute that you're dealing with. Again, that's not critical in terms of having that subject matter. I mean, a good process person is probably worth more than someone with content knowledge, because as a mediator, you're there to focus on the process, not to give advice or make recommendations on content. You'd also want to be sure that the mediator is accountable to standards and ethics, and that comes along with someone who's signed up to a professional organization or a panel. You'd also be clear on the fee rates, and what I also think is really important is that someone besides the mediator handles the payments, because that becomes such a tricky issue with the mediator having to manage their independence and their impartiality in a matter. If there's money involved and one party's paid and the other hasn't, and they're kind of those issues, it could just kind of cloud the impression of the mediator if the mediator's having to deal with it. I mean, we definitely keep that well out of the picture when we set up mediations. And then also just making sure that there's some kind of proof of professional indemnity insurance, that your mediator has signed up to that insurance and is covered in the instance that it may be necessary. So those are some of the really objective criteria that I think you as representatives will be considering in choosing mediators. There are, of course, a whole lot of subjective matters that come into play, and that's, sometimes you just warm to a mediator. You like working with a specific mediator, you like their personal style, you trust them because of other experiences you've had with them. The credibility to the parties and their representatives is critical. If you've got someone who both parties buy into, there's so much less of that initial struggle to develop rapport and develop trust between the mediators and the parties. Reputation of the mediator often really assists, and their standing in the community can also add to you choosing them. But those are much more kind of subjective criteria, and I think look at those initial more objective ones before you put your lenses in terms of the subjective ones. Okay. Preparing for the mediation day, I think from what I've been saying here, it's really important to prepare your strategy, to prepare the process, understand the process you're going in, be prepared to mediate rather than to litigate, and to be emotionally prepared for the process too, because it is quite a exhausting process, and it takes quite a lot out of all the people involved in the process, really. The other thing is preparing your mediation statement and the mediation file. It's really useful when that is thoroughly done. I mean, I've had a couple of mediations where each party walks in with a different bundle of documents, and there's a whole lot of duplication of documents, and they're kind of arguing about that before the process even starts. If there are, you know, 2 mediation statements or even 1 mediation statement, and they've been shared before and it's clear, it really does get you off to a much better start in your process. And then also a lot of preparation in terms of the opening statement, who makes it, what you include in that opening statement, what tone you hit in that opening statement, makes a big difference as well as to how things go. And then finally, also just preparing a sort of a template for the settlement agreement. If you're going into mediate, you're going in with the attitude that there may be a settlement. So be prepared for that. Have your template ready so that when it happens, you can just, you know, be quite quick to draft a settlement and wrap things up. Okay, any questions relating to that? Okay, now just some unashamed advertising. We run mediator training, as many of you would know. You've trained with us. We've got training happening. We hopefully have training happening in Durban in May from the 19th to the 24th, which is very exciting. We haven't trained mediators in Durban for many, many years. So hopefully we'll have a group together and be able to do it face-to-face in Durban on those dates. And then we've got processes scheduled for the rest of the year. There's another one in Johannesburg, again in person, and an online training in September. We also run these one-day mediation advocacy courses where we go through the skills that back up a lot of what I've said today. So you get to practice them, you get to kind of really try some of these skills before you try them on clients. We always argue that that's been really interesting to be training those advocacy courses. And it's been really interesting to see how people we trained, legal firms specifically, who would send, you know, a whole team to training about, I would say about 18 months ago, are now coming through and requesting mediations, and how much, you know, how much easier it is and how seamless it is when the attorneys are really well prepared and well skilled to deal with these cases. So we've got a couple of those coming up too that have already been scheduled, and of course we'll do them in-house or for specific institutions or the likes whenever there's a request for them. Okay. And that's kind of all I've got to present, and it doesn't leave us with a hell of a lot of time for questions. I'm glad I did give you opportunity during the presentation to ask questions, because I have really chowed through that hour quite effectively. Any comments or questions?
Just while we're waiting for questions, perhaps I can reinforce everything Marion said. There's been a huge focus on training of mediators and upskilling of mediators. And I think there needs to be an important shift now, which Conflict Dynamics is leading in training attorneys to participate effectively in these processes, acknowledging that the attorneys have a very important role to play, and also acknowledging perhaps sometimes need to know their limitations and be prepared to upskill to be able to participate effectively. And yeah, a very important component of evolving the practice of mediation in South Africa. So thanks to all the work that Conflict Dynamics is doing in that space. Any questions, final remarks? So if not, Marion, then just to say, this webinar was hosted by the KZN Society of Mediators, and the society really values and appreciates our relationship with conflict dynamics. And we look forward to collaborating more closely with you in future. I'm just going to hand over to Ishara, our chair of the society, to do the vote of thanks. Thank you.
Thank you, Michelle. Can you all hear me? Am I unmuted?
Yes.
Okay, great. Yes, so thank you, Marion, for making yourself available. I know you have a very busy schedule, but thank you for making yourself available, and for a much appreciated input that you've made on our webinar series. I myself have picked up a few tips, not just as a mediator, but also for the society to assist as our association. So thank you very much. And thank you, Michelle, for facilitating this and for organizing it. I myself trained with conflict dynamics, and I think it's wonderful, the work that you are doing. So thank you once again. And to all our members and non-members who have attended.
Such a pleasure. Thanks so much for having me, and yeah, keep up the good work. What can I say?
Thanks, Marion. Goodbye, everybody.
Goodbye.